And welcome back, everyone, to the National Veterans Small Business Coalition's Charlie Mike Training Series. I'm Zach Armstrong, the Deputy Executive Director with NVSBC, and I'll be your host and MC today. Before I introduce our speaker, let's just kick things off with a few announcements and updates, and we'll get the show on the road. So our sponsors, we are incredibly grateful to have three amazing sponsors today. These sponsors work closely with us to provide you these trainings from policy experts, government representatives, and GovCon educators to bring you the information, best practices to grow and sustain your GovCon business. So thank you, BAE Systems, Philips North America, and Bank of America for making today's training possible. It's that time of year, folks. Our Vets 23 conference is May 22nd through 25th in sunny Orlando, Florida. We hope you join us. This conference is brought to you in partnership with the U.S. Department of Veterans Affairs this year. So registration is available. Register today. Join what we're tracking to be north of 750 participants, sponsors, vendors, and more this year. A lot happening down in Orlando, and we hope you join us. Our Vet Academy and DC networking dinners, these provide monthly opportunities for training in the Washington, DC metro area, all different types of ways to continue to grow your business. We bring you thought leaders, decision makers, providing their expertise, their updates. Come meet them, shake their hand, meet your colleagues, even folks like our speaker. We've been lovely enough. Brad's been able to join us at these events. So come join us at our trainings and networking dinners. Dates are available there for you and available on our website. Our Entrepreneurship Through Acquisition conference is available. Come join us on February 7th from 12 to 2, co-hosted by NVSBC and SB Liftoff. We'll have hundreds of capital providers, lawyers, M&A professionals, accountants, business schools, and supporters of veteran ETA. Registration's available today. I know we already have several hundred ready and chomping at the bit for this great conference. And lastly, while you're here today, some of our in-person or our virtual trainings, from our Charlie Mike training series. So this series has grown substantially over the past 2 years since we introduced it. And we've moved from a live webinar style session to a recorded session, which is hosted on our YouTube channel. So please do subscribe, like, and view. With our GovCon focus areas in 2023 being business planning, business operations, business leadership, along with federal agency opportunities and prime contractor opportunities, we're looking to grow this training series even further. So again, it's my privilege to be your moderator today. Just 2 quick notes. I want to send thanks to all of those who sent in questions ahead of time through registration. I'll be providing those questions to our speaker at the end. And then lastly, I'll be helping to moderate this series. A lot of you know our program director, Earl Morgan, who is retiring at the end of May. He and I are going to share some of these responsibilities until he departs and goes off with his own SDVOSB business. So with that, here we go. Mr. Brad Reaves. At NVSBC, we are proud to present Brad as a speaker today. He's a partner at the newly named Reaves GovCon group. I actually got a chance to meet Brad in person for the first time last week. And it's always good to shake someone's hand and see them in person and hear their message. So Brad, thank you in advance. With that, I'll, turn it over to you so you can start to, I'm not going to impede any more knowledge transfer to our hungry audience. So with that, welcome, Brad, and the show is yours.
Thank you so much, Zach. I really appreciate it. Certainly appreciate the opportunity to speak. It was also good to meet you live. I want to make sure people know that we're providing good, timely, accurate information. So I don't want anybody to be thrown off the fact that both Zach and I have slightly less gray in our beards in our pictures that just went up on the PowerPoint, but I did take note of that, Zach. So
I love it. Yep.
Those maybe we're going to have to update. We have to update with a little bit more gray.
So if we have a conference, we might get some pictures together. But I appreciate it. I'll hold you to that, Brad. If you change your picture, I will.
That's right. That's right. We'll do it. Well, again, appreciate everybody's attention for this presentation. This it's a very exciting topic. It's exciting for me to talk about joint venturing and to talk about joint venturing, particularly within the SDVOSB, VOSB community. This is something near and dear to my heart in the sense that ever since the SBA expanded the joint venture program back in 2016, I have put together literally hundreds and hundreds of these joint venture agreements and have seen, I think we'll talk about this in the presentation, increasingly the federal government become more receptive to the use of joint ventures. Certainly the Small Business Administration has implemented a number of rules that have helped to leverage the joint venture vehicle across multiple procurements. We'll talk about that. But this is a tool that I have seen in the toolbox that has helped many a small business and a service-disabled veteran-owned small business grow and bid on very large opportunities. So I hope that this information is helpful to you all. Even if you are already familiar with joint venturing, I think this will be helpful because we're going to, we're going to start out at maybe like a 10,000 foot level, but then we're going to really get down, not into, I wouldn't say into the weeds, but we're going to get to some pretty nuanced issues that come up with joint ventures, particularly these highly regulated joint ventures between a service-disabled veteran small business and either another small business partner or, as we'll talk about, a mentor and a mentor-protege arrangement. So maybe one thing that's important, obviously you're part of the presentation right now. If you'd like a copy of this training, you can email me right there, brad.reaves, R-E-A-V-E-S, at reavesgovcon.com. If you email me, I will respond and I will provide you with a copy of the whole training. There are some live links in the training so that if you get that presentation from me, you'll be able to link to a couple of different places, a couple different SBA locations. So that hopefully that'd be helpful for you. Let me start with an overview of where we're going to go today in the program. Like I said, we're going to start at about a 10,000 foot level where we're going to look at fundamentals of joint venturing generally. And then I want to talk a little bit about the mentor protege program and how joint venturing interacts with that for SDVOSBs. So this is not by any means a deep dive into the mentor protege program. I do those presentations and, I could spend an hour and a half talking about the mentor protege program. So we're not going to do that, but it is going to be enough so that you understand the interplay between the mentor protege program and the joint venture program for SDVOSBs. We're then going to talk about SDVOSB certification and how those recent changes and the shift over from the VA to the SBA is going to impact joint ventures and SDVOSB joint ventures. Then we're going to get into more of the specifics, the specific rules and regulations that govern joint ventures that involve a service-disabled veteran-owned small business. We'll talk about a couple of recent cases and recent regulatory changes. And then, as Zach mentioned at the end, he's going to come back with some questions that have already been submitted. Some of those will sort of hit, as we go through. But, I think at the end, it'll probably be a good way to re-emphasize some of the more important points as we hit the questions that come in. So that's where we're going today. And I apologize in advance. I'm a lawyer, so I got to give a disclaimer. Can't give a presentation without a disclaimer, right? And the disclaimer is just this, that this is good, relevant, current information, but just be aware that if you need specific legal advice, you need to get legal advice from an attorney, and preferably if this is what you're doing, if you're in this government contracting space, get involved with somebody who's familiar with small business, SDVOSB, government contracting rules and regulations. That's important because this is a highly technical area of the law, and that's what I won't say much more about myself. Zach did a good job with the intro, but I started about 11 years ago after working at a big law firm doing government contracts practice. started a boutique firm. We're small. We're just about 7 attorneys. We're based down in southeastern Virginia with an office in Reston and Richmond, but our full focus is on government contracting industry. And most of my clients are in various set-aside groups. Probably the majority of those are in Service Disabled Better Known Small Business Council. And for many years have been, presenting and doing training topics like this for MVSBC and other national groups. I love speaking on these topics. And so with that, let's jump into real stuff here, into the details. Let's start with the fundamentals on joint venturing. Let me start with kind of the biggest issue or the biggest question. This is, I would say, a misconception that's out there regarding the joint ventures and how they work and size of businesses to a joint venture. Inevitably, I will get probably this call several times a month where somebody will reach out and they'll say, hey, we're looking to joint venture on this opportunity, and they could be a SDVOSB. Excuse me. And they'll say, hey, I found a large business partner that I want to use, and we're going to joint venture and go after this SDVOSB set aside. Maybe it's some large project. It could be a large procurement. It could be a GWAC. And the first thing I'll say is, okay, well, if they're large, and they might not even tell me they're large, just say we have a partner, and I'll say, okay, well, what's the next code that applies, the NAICS code? What's the next code that applies to the procurement? Obviously you guys are small, you're SDVOSB. What about them? Are they small? And they'll say, well, I don't know. Or they'll say, oh, no, they're large. And then the next thing I'll say is, well, you cannot joint venture with them on this procurement unless they are your SBA approved mentor and you are their SBA approved protege. So one, I think, misconception that's out there is that you can just enter into a joint venture with anyone, and that's not true. So both of the members of the joint venture must be small. All right. If you want to create a Service Disabled Better Known Small Business joint venture, both of the members of that joint venture must be small under the next code that is assigned to that procurement. Now, you can also have, this is rare, but you can have more than 2 members in a joint venture. And in that case, all of them would need to be small. So let's say if your size standard is $41.5 million for a procurement, you could, as a SDVOSB, have a 5-year average annual revenue of $40 million. So you're under. You could have a small business partner that's at $40 million, and that works. You could have 2 small business partners that would be in the joint venture with you. As we'll talk about later, you'd still have to be the 51% owner and in control of that joint venture, but you could involve 2 of them as long as they're just under that $41.5 million. But if they are at $42 million on a 5-year average, like I said, if the size standard is 41.5, then that means they're large. That means you cannot joint venture with them unless you go through this process, which we'll talk about in a little bit. You go through this whole process with the SBA to get them approved as your mentor. The mentor protege agreement is the only way in federal contracting that a large business can joint venture with a small business, and then that joint venture go after small business and set aside procurements. So that's got just kind of big picture there to understand size and how that matters. Here is, I would say, again, we're at like the fundamental, like this is trying to get your attention at the beginning here. This is what I would say is perhaps the most important advantage of a joint venture for SDVOSBs. And I've actually put the regulation, you'll see, I try to keep plain language as much as I can, but this is one situation in the presentation where I've included the detailed language from the regulation, because it's important. So I've tried to bold it and underline it strategically here. So this language essentially forces contracting officers to consider the past performance, the capabilities, the experience, the business systems, the certifications of both joint venture partners when they are evaluating the joint venture itself. So when they're evaluating the joint venture, they're not just looking at what the joint venture has done, and they're also not just looking at what the SDVOSB has done, or the small business, or the large business mentor. They are looking at both, and they have to look at both. And then look at this next section here in the regulations where it says that it says that the contracting officer must consider work done and qualifications held individually by each partner to the joint venture. And then this other very important part, may not require the certified VOSB or SDVOSB to individually meet the same evaluation or responsibility criteria as that required of other offerors generally. That means they cannot, the contracting officer or in the RFP, they cannot create a situation where they say, okay, well, your partner has it, but you don't have it, so then the joint venture doesn't have it. They can't do that. Here's the thing, though. Sometimes they still do. They still do try to do that. And so there have been, ever since this actual regulation, it started out in a more truncated form. It wasn't quite this expansive where they have this whole list of capabilities, past performance, experience, business systems, certifications. It didn't used to be that long. It used to just say past performance, right? But the SBA has continued to expand this. And so what's happened over the past couple of years is that agencies have not all been up to speed on the existence of this regulation, or maybe if I'm being a little bit cynical, they may not love this regulation because it really does allow you to leverage your joint venture partner's experience and capabilities in a way that ties the agency's hands. In other words, they can't refuse to consider that information. Whereas, here's the difference. According to GAO cases, if it's a traditional prime sub teaming arrangement, then the agency can decide whether or not to consider the past performance of your sub. Now, whatever rules they put in the RFP, they're going to have to live with. But if they don't say anything, then they can either consider your subcontractor's past performance, or they can not consider it, and there's nothing you could do in a protest at GAO. They have the discretion to do either. But guess what this regulation says? They don't have the discretion. They have to look at the past performance and capabilities and resources of both joint venture members. So hopefully you hear me loud and clear that this is an extremely important part of an advantage of a joint venture, because there's nothing out here that's similar to this generally that operates across all small business, set aside joint ventures. This is how that works. Now, here's another fundamental change, and that is in the way that the joint venture itself can be utilized. There used to be something called the 3-in-2 rule. So the old rule is called the 3-in-2 rule. And what it generally said is that once you create a joint venture, that new joint venture entity could not win more than 3 awards in 2 years. Otherwise, you had to wrap it up, because a joint venture is supposed to be a limited purpose entity. It's not supposed to stay out there forever. So it was 3 awards in 2 years, although there was some nuance in how you calculate it, so you could technically get a few more awards. Well, they've scrapped the 3-in-2. Instead, the new rule says that you can obtain an unlimited number of awards, contract awards to the joint venture within a 2-year period. So you start the time clock ticking on the day the joint venture is awarded your first contract, not the day you create it, but the day you're awarded your first contract. And then you calendar 2 years out from that date, and you could submit as many proposals as you want during that 2 years. And then on that 2-year anniversary, you stop submitting proposals. And then any awards, any bids or proposals that are out there on the street, if they come in as awards, that's okay. And you could get 100 awards for one joint venture. You can see how this greatly expands the use of a joint venture. And that's one of the beauties of a joint venture versus a teaming agreement. A teaming agreement is for one opportunity. It has to be defined, specific, one opportunity. A joint venture can be put in place and used across a number of opportunities. And the last bullet here, I just mentioned that it does appear that there's an increasing recognition by government agencies that joint ventures, and I'm including SDVOSB joint ventures, are able to perform on much larger procurements. We'll talk about why that is, but larger IDIQs, MACs, GWACs. I think there's a recognition that if we're going to be setting aside contracts worth tens of millions of dollars, or in some cases $50 million, $100 million, that small businesses and SDVOSBs need to leverage capabilities of other partners, and that a joint venture is a good way to do that. Again, we'll talk about some of the reasons why. Now, let me, again, so that was sort of a jump into some of the fundamentals for joint ventures. Let me pull back a little bit and talk a little bit about mentor protege program, which I led with, talking about how the joint venture can allow a large business to joint venture the mentor protege program can allow a large business to joint venture with a small business. So let me tell you a little bit about this program. It's called the All Small program from the Small Business Administration, All Small Mentor Protege program. This is the only way, as I mentioned at the start, this is the only way that you're ever going to be permitted to have a large business be your JV partner as an SDVOSB. It's the only way that can happen, which is could be a huge advantage, right? So you could have $1 billion company as your JV partner and yet be bidding on small business and SDVOSB set-aside procurements. And they can get, as we'll talk about later, they can get up to 60% of the work, up to 60% of the profit, maybe even more if they make an investment in you as a protege. So there's all sorts of upside potential here for the mentor, for the large business mentor. But I will mention that the mentor doesn't have to be large. It's just a lot of times that's the case. Because if they're not a large business, then you don't necessarily need the mentor protege agreement unless there's some other reason that you would want it to be in place. But that's why this mentor protege program is so huge, because it permits large businesses to joint venture with smaller SDVOSBs to bid on these procurements. It also allows, you might say, well, what else? Is joint venturing the only thing? No. It can also allow a mentor to provide other assistance to you, contracting assistance, business development assistance, all kinds of assistance. And then, as I alluded to, mentors can obtain up to a 40% ownership interest in the protege. They don't have to. You're not required to give it up if you're a protege, but it's a possibility there. And you don't have to worry about affiliation under the SBA's rules. Those of you who understand affiliation is just this concept that your business may not be small if it's too closely aligned with another business and the SBA views you as being under common control. Or if it's a large business and it feels like that they're sort of like your puppet master, the SBA could find you to be affiliated with them. Well, as long as you have an approved mentor protege agreement, that's going to protect you from a finding of affiliation. All right, so how do you know whether you can get into the program? Well, it's pretty straightforward. The service disabled veteran-owned small business or the small business, they got to be small under their primary NAICS code. Now, if you're large in one code and you're looking to transition to do a different type of work, you can get a mentor in another. There's a separate code, a secondary code where you're small, but they won't let you get one of these mentor proteges if you've never done work in that area. They're going to look at, the SBA will look at sam.gov to confirm the SDVOSB status. But just remember, we'll talk about this certification move in a few minutes. Just remember that, the certification is now moved over to the SBA. So that means as of January 1, 2024, you must have an approved SBA certification. You must either have that approved, have it pending approved, or be grandfathered in because you got your CVE certification done, within the past 2 years at the CVE, which allows you to go for your full 3-year period. So one of those things has to be the case in order for you to qualify as a SDVOSB under a mentor protege. Here's, again, this is why you can email me and get the link to the presentation. I've got a link here to the portal to get through the application. You have to submit, again, the main thrust of this presentation is not the mentor protege program. I just want to make you aware of it. We'll do that on another one, Zach. All right. Well, we'll do mentor protege coming up here in the future, a little bit more deep dive.
Sounds like a plan.
All right. We'll do it. Maybe even down in Orlando too. You got me excited. I'm definitely coming down to Vets 23, and the mentor protege might be a good subject to talk about down there. So in terms of application procedure, I've got some information here. I've got a link to, the business plan. They want you to submit a business plan. I got a link here to the mentor protege agreement. If that's something you're really interested in, tell me in your email when you request the presentation. I'll send you the SBA's form agreement. So anyway, there's a process to work through with this agreement. But once this is, what the page 1 of the agreement looks like, it's really just kind of an outline of 5 or 6 pages. You're the one who has to fill it in and populate it with the type of assistance that the mentor is going to provide, and then the type of assistance you need as a protege, which could include joint venturing. Again, one of the primary reasons people enter into these. So that's kind of it. That kind of wraps it for mentor protege. But just understand the big takeaway there is if you want to joint venture with a large business, you've got to explore that program and get that in place. You cannot submit a proposal as a joint venture with a large business until the SBA mentor protege agreement is approved. And right now, unfortunately, they've been taking upwards of like 100 days to approve these things. They used to do them real fast. I feel like they must be short-staffed, or people are just doing them like crazy. I know there's over 3,000 participants in the program right now from the mentor and protege side. So I don't know if they're short-staffed or what, but earlier this year, they were tracking to like 110 days to turn around these applications. So you've got to have that approved before you submit as a joint venture with a large business. So let's talk a little bit about these brand new certification regulations. They were published in 13, or they're part of the federal regulations in 13 CFR 128. Let's talk about how that impacts joint ventures. So just as a quick recap, and I know you all have heard that those who are connected with NVSBC know, because NVSBC has been talking about this for over a year, ever since we had the 2021 NDAA. What the National Defense Authorization Act did is it eliminated SDVOSB certification, but did so in a gradual manner. So what they did is they said, okay, we're going to move the certification process from the VA over to the SBA, but we're going to allow for some transition time. First of all, they allowed for a couple of years for the SBA to come up with the plan, but then we're going to allow for a transition time of 1 year for SDVOSBs and VOSBs to go ahead and get certified through the SBA's process. And like I mentioned earlier, as long as you get your application in before the end of this year, then in other words, as long as you're in a pending application status, you will be able to continue to rely on that self-certification. But of course, get it in as soon as you can. I think I heard something that said that 600 applications came in on the first day. And I can't remember the number off the top of my head, but I want to say maybe there's 35,000 SDVOSBs out there that are self-certified. It's a big number. So if everybody's got to march through this year, it's going to be a lot for the SBA to process. So as of January 1, 2023, the SBA has this new certification program that came from the VA, which they call Vet Cert. I've got a link to it right there. That's the Veteran Small Business Certification Portal. Right now, what they're saying is that really this is what you need to be able to bid on prime contracts at the VA or outside of VA as a SDVOSB. Now, as a VOSB, as you may know, there are only prime set-aside contracts at the VA. There are no other VOSB set-aside contracts in federal government contracting, only at the VA. But VOSB status does matter for subcontracting purposes if you're talking about a small business plan for a large business contractor when they're trying to hit certain goals in their plan. Okay, so this bullet here on self-certification, again, I'm trying to describe this as like a rollout. It took 2 years to implement. There's a 1 year sort of like grace period. But then the next piece is that for subcontracting or for just agency goaling purposes, they are still for the next 5 years going to allow you to self-certify. So in other words, I'm not necessarily recommend that you don't get certified, but if you do nothing but subcontracts and you never plan on doing anything but subcontracts, or at least for the next 5 years, you can continue to self-certify, right? Now, your primes might not be okay with that. Your primes might say, you know what, we want you to go ahead and get certified because that might make them nervous. But in terms of the federal government and the SBA, they're going to wait 5 years to roll that out, where they're going to require everybody who's doing certification or has SDVOSB or VOSB status for subcontracting purposes before they require you to get certified there. Those new regulations are going to, you'll see them there at 13 CFR 128. If you're interested to look at those, an easy thing to do is just input into Google 13 ECFR 128. If you put the E in there, it sends you to the Electronic Code of Federal Regulations, which is free to look at. And they've got all the most up-to-date regulations there. I mentioned this before, but just to reiterate, if you did get verified under the old program, that's the VA's program, then you're good for 3 years from that date. So if you're one of the lucky ones that got in at the end of 2022, then that means you don't have to mess with this again until 2025. You can just sit back and laugh at all the other people who are having to go back and go through the SBA. And who knows, I'll be interested to see how long it takes them to process this first batch of applications that's come in. If anybody knows and if anybody's done it, email me and let me know. I would love to know or who's done it, who gets it back, and let me know what the lead time was. I'd be very interested to know how long it took them to do that. All right. So how does all this? So hopefully that was a good refresher. But how does all this impact service disabled veteran-owned small business JV certification? Well, under the old regulations, you might remember that the VA required JVs, the SDVOSB JVs or VOSB JVs to be separately certified by the VA. So the process was you had to, if you're SDVOSB, you had to get CVE verified. And then to enter into a joint venture, you had to put that together and then resend that to the VA to get them to verify that entity. Well, under the new program, I guess if there's good news of the program, this is one of the pieces of good news. Under the new program, joint venture certification is no longer required. You don't have to get it. And that's even for the VA. So it's kind of an interesting wrinkle here to these new regulations is that joint ventures to bid a VA or outside of VA or anywhere in federal government contracting, they do not need to be approved. So keep this straight in your mind. I always get a lot of questions about this. People say, well, wait, you said the mentor protege agreement had to be approved. Well, does a joint venture agreement have to be approved? The answer is no. A joint venture agreement never has to be approved, even if it's between a mentor and a protege. The only time left that joint venture agreements have to be approved is if you are in the 8A program and you're trying to get sole source contracts. So if we have any folks out there that are a combo of an SDVOSB and an 8A at the same time, there could be a situation where the SBA local office needs to approve your joint venture, but that's a nuanced, very technical exception to that rule. Now, they did roll out this interesting rule, though. They've said, okay, well, there's no certification required for a joint venture, but the VOSB or the SDVOSB cannot be a joint venture partner on more than one joint venture that submits an offer for a specific contract set aside or reserved for VOSB or SDVOSB. Here's what that means. You can't sort of bid against yourself. You can't be on a JV that's going after an opportunity as an SWSB and then be on another JV that's going after that same opportunity. They've made clear that you can't do that. I think there's some other issues for doing that maybe as well, but they've just made that absolutely clear in the regulations. All right, let's talk about the specifics here, drill down a little bit more to the specifics for SDVOSBs on joint ventures. Because remember, this program is for all small businesses and all set-aside businesses, woman-owned, hub zone, 8A, in addition to service disabled veteran-owned. So quick refresher on joint ventures themselves. The FAR, Part 9.601, talks about contractor teaming arrangements, and that would include both a teaming agreement and a joint venture. It includes both, but a joint venture is different from a teaming agreement. At a high level, a teaming agreement, you really only have one party. If you think of the prime and the sub right here, you have the government up here above the prime, and that's really the only two parties who are connected with the contract. They have a contractual connection between them. The sub sits down here below the prime, and therefore they have no contract with the government. Whereas you want to think about a joint venture, you can almost think about the joint ventures as being on equal field and both connected with the government prime. So they can reach out and touch contractually both JV members. In lawyer speak, this term is called contractual privity of contract. It just means you have a contract connection with the government. So a sub can't submit anything directly to the government in a traditional teaming arrangement, whereas there's actually a really interesting provision that's a unique provision of joint ventures where you have the two JV partners. If one of them, let's say it files for bankruptcy, and the other one is left, the joint venture agreement has to provide that that remaining partner will continue to perform the work. Whereas if you have a prime and a sub, and the prime files bankruptcy, then they're going to get terminated for default, terminated for convenience, default, and the sub doesn't just get the work, the government's going to have to reprocure or do something else. So that's, you can start to see maybe why the federal government and these various agencies would start to realize it's almost like they're getting two prime contractors for the price of one, which could give you more comfort, particularly as you get to larger and larger procurements. All right, so what about sort of like the nuts and bolts here of setting these things up? Typically, a JV is going to be set up as an incorporated entity, and usually that's being set up as a limited liability company. That new entity, it's a new business you're creating, is the bidder to the government. You can probably think of the two JV partners almost like they're super subcontractors to this new entity, the JV entity. Under current regulations, generally, that entity, that new JV entity that you're creating, is going to be unpopulated, which means it's not going to have its own employees. Now, there are some nuances to there where you can, on a limited basis, populate for facility clearance purposes. There's a new rule that had just been announced where the SBA says, well, if you're both similarly situated entities, so if we have two SDVOSBs that decide to create a joint venture together, and those are the only two folks in the joint venture, that they might be able to put some employees into the joint venture entity itself. But other than that, generally 99 times out of 100, the joint venture entity itself will have no W-2 employees. Instead, all the work it does will be performed through JV partner number one or JV partner number two. So the SDVOSB, and then the small business, or maybe that's the large business mentor. So that's how the architecture of a joint venture is set up. As I mentioned, usually set up as a limited liability company, but that means you got all the same things that come with creating a new business. You got to register it in SAM. You got to get the UEI, maybe a DUNS 2, cage code. You have to go in and flip the switch. You know, if you're SDVOSB, you need to go in and your reps and certs and click off, this is an SDVOSB joint venture, because that's what a contracting officer is going to check when you use this joint venture to bid on an opportunity. What are the benefits? What are the benefits? Why would we be doing this? So this is a very important slide right here. If maybe I should have put this up front, I don't know. Hopefully nobody's fallen asleep or too distracted in their emails or multitasking, but listen up to this slide. This is an important one. So number one, I mentioned this, unlike a teaming agreement, you can put the JV entity in place and it can cover multiple RFPs and contracts, not just one. So they're highly they have high utilization, or their utility is high, or I don't know if there's any other better way to say that. The management control and profit loss and distribution issues usually get taken care of more upfront in the joint venture agreement that you create. So that's a positive to joint ventures, that you're not dealing with this scenario where, you know, you have a teaming agreement. And those of you who are very familiar with teaming agreements, I deal with a lot of them in Virginia. Virginia law is pretty antagonistic to teaming agreements. It's not like California, where in California you can just about create an oral teaming agreement. But in Virginia, if you have a teaming agreement and it says, you know, we're going to bid on this contract, and if we win it, we're going to negotiate with each other and we'll decide on a subcontract later. In Virginia, that's not enforceable. Even if it says a good faith negotiations for 60 days, and then if we can't reach an agreement, then there's no agreement, that's not enforceable. So with a joint venture, you're getting more security because you've created a new entity. And if that new entity wins the contract, you've got an ownership right as the JV partner, for instance, or as the SDVOSB partner. You have an ownership right in an entity that has been awarded a government contract. That's very different than having a right to have a prime contractor issue you a subcontract under a teaming agreement. So that's one of the benefits of a joint venture agreement. More enforceability in terms of work share, yes, for sure, for all those reasons I just mentioned. And I mentioned this from the government's perspective, their ability to kind of reach out and touch both contractors, both JV members, is a benefit of joint ventures from the government side. But here's the biggest one, and especially if you're one of those overachieving small businesses that's either done really well or you plan to do really well in terms of your revenue. Obviously, all of these, your size is dictated by, okay, what sort of sub industry or sector are you in, and what is the number for that? Is it 15 million? Is it 25 million? Is it 41 million? What is the number? Well, generally speaking, in a prime sub relationship, if you win something as a set aside contract, as an SDVOSB set aside, you're the prime contractor. If that's a $10 million contract, then even if you subcontract 5 million of that to a large business or to whoever you subcontract it to, all $10 million falls to your bottom line for size determination purposes, right? So when you're deciding whether you're getting too big for your code, for your size standard, that's when you're going to, you have to include all that revenue. Here is the big advantage of joint ventures, a huge advantage of joint ventures. When you have a joint venture, let's say it's that same $10 million contract, prime contract, you're going to perform 5 million and your JV partner is going to perform the other 5 million. Even though your profit margin is probably going to be exactly the same in the joint venture context, only 5 million of that 10 million falls to your bottom line for size determination purposes. Okay. So that is a huge consideration if what you're trying to do is maximize your time in a given code, under a given code. So you can, if you're bidding then as a joint venture, as opposed to a teaming agreement, prime sub relationship, that enables you to keep the same profitability, but just not put as much money towards that revenue cap. So hopefully that makes sense. It's not something I would say every government contractor understands. It's something I would say that I've seen, especially over the past 5 or 10 years, in doing a lot of mergers and acquisition work, buying and selling of government contractors. Joint ventures are key. Joint ventures are key in helping people maximize their time in a program, maximize profitability in the small business program, in the SDVOSB program before sort of sizing out. And then because of the mentor protege program, you can create a mentor protege relationship where you then create other joint ventures. And then that, again, that helps reduce your revenue for size purposes. So again, those are big benefits of joint ventures. There are others too, but these are sort of the main ones. So I did benefits. I guess that means I have to do drawbacks. There is the risk of sharing, the fact that you're sharing not just profits, but losses. And so you may have some exposure. Now, if you were otherwise going to be a prime, you're always going to have sort of exposure and risk. But let's say for your JV partner, they're now going to be taking on some more risk, than if they were just a firm fixed price subcontractor, right? There are costs associated with setting up a joint venture. There's people like me that you have to pay to put them together. So there's legal costs. There's the legal formation of a new entity, business license, tax filings, the ongoing logistics to maintain the company year to year, security clearance issues that can cost time and money. So there are some risks or costs or drawbacks, but those, again, because of all those benefits, once you understand how to utilize a joint venture, how to set them up correctly, then that actually, I have not found these drawbacks or these costs to be significant impediments to those people who are adept and have real opportunities. Like if you have opportunities to go after, then it's usually worth it. Again, the clients make those decisions, but we try to just give them information to make those decisions. But I've seen people be extremely successful. I have one particular client who has been so successful with mentor protege and joint venturing, partnered up with a graduated SDVOSB, one that was no longer a small business, entered into a mentor protege agreement with them, and just started winning some very large awards. I've seen this happen multiple times, but there's just one in particular I'm thinking about where, they just won an $80 million contract through this joint venture. And it's all because they're leveraging sort of the past performance, the experience of that mentor. And then, for the small business, and this SDVOSB happens to be an 8A at the same time, it's able to maximize its time in that program by winning an $80 million contract, but not having $80 million go to its bottom line for size purposes. So then all of a sudden, boom, it blows out of all its set-aside programs. All right, I'd already mentioned this, so I don't have to beat this dead horse, but just that 3 and 2 rule went away. So remember, the joint venture can be used as much as possible over that course of 2 years, starting with the date of the first award. But here's the thing. Once the 2 years ends, you can create a new joint venture with the same 2 parties. You can do that whether it's a mentor protege or whether it's not, whether it's just a SDVOSB in a small business. The SBA does say that at some point you can create so many joint ventures with the same company that they'll find you to be generally affiliated. I've honestly never seen that. I've helped people create 2 and 3 of these things. I would say, people say, well, how many can you create? You could certainly do 2 with no risk. Maybe there's some risk if you do 3. Once you start getting to maybe 4 or 5 or more with the same company, you're probably getting towards a riskier situation. And I don't know that I would recommend that. But because you can do unlimited in 2 years, you really can get on a lot of vehicles. Remember, if you get, or I say remember, but I haven't made this clear, and I think there might even be a slide later that clarifies this. If you get an award on a multiple award contract or IDIQ contract, you get the award with the joint venture, but then the task orders do not count as awards during that 2-year period. So you could get on a 5-year IDIQ, and as long as you get that award within your 2-year window, then you're good for the next 5 years. You can bid on as many task orders as you want, and in other words, the task orders don't have to be awarded in that 2-year window. So I hope that makes sense. All right, specific regulations on joint ventures. Now, I'd already told you how to go to the ECFR, the Electronic Code of Federal Regulations. Well, what I've listed up here are the specific regulations that deal with mentor-protege joint ventures, that deal with 8A joint ventures, that deal with service-disabled veteran-owned. Obviously, that's our focus here, 13 CFR 128.402. But also hub zones and women-owned, economically disadvantaged women-owned. So each one of these, again, if you just plug it in, 13 ECFR 128.402, that's going to show you the specific requirements the SBA has that they want integrated into your joint venture agreement for a joint venture. And I will just tell you the way I do this. I've been doing this for years, and I think it's the most streamlined approach. Whenever people, get my help to create these agreements, since I'm already creating an LLC and the LLC is going to need an operating agreement, I create a consolidated joint venture agreement and operating agreement, both as one document. So it's a cohesive, comprehensive document that's consistent with itself. I've seen a lot of other people break them up where here's the operating agreement, here's the joint venture agreement, and the terms, it's hard to get the terms to coincide. So I create that as a consolidated agreement, but that agreement is going to have to include all of these regulations that you see there, all of these various requirements. And so I'm not marching through all of the requirements here, not at all, not even close, but I just want to alert you to some key requirements for SDVOSBs. So as I mentioned before, there is no approval process for SDVOSB joint ventures. You don't have to get anybody to approve it, which is good. I think it's a good thing, right? It's helpful. However, just because you don't have to get anybody to approve it doesn't mean you can just throw something together or, quite frankly, try to do this on your own because it's dangerous. The mentor protege, people can put mentor proteges. I've helped people do that. I do it a lot, but it's not, it's that document is not a legal document in the same way an operating agreement is or a joint venture agreement is. These are the requirements of these regulations are very technical. So I would highly recommend, getting some help, some professional help when you put these things together. Here's why. So I just said, you don't have to get it approved or certified, but you do have to make a certification that you have entered into an agreement that fully complies with the applicable SDVOSB regulations and that you're going to meet all the appropriate performance or work requirements. So that is required. And anytime you're a federal government contractor, you should be, your ears should perk up whenever I say the words, you're going to certify. Because if you certify something to be true, and it turns out not to be true, you turned out not to have entered into agreement that fully complies with the SDVOSB regulations, or you turn out to not have met the performance of work requirements, then that means you falsely certified to the federal government. That's a false claim, a false certification. It can create a parade of horribles that you don't even want to hear about. And that's sort of what they've done here is they've set this up to where, no, you don't have to go get this joint venture approved or certified, but because you're going to have to make this certification that you've done it right, if we ever find out you didn't do it right, or somebody blows the whistle on you, or if you're audited, then we're going to nail you to the wall with your false certification that you will have submitted. So that's something to be aware of. All right, some other specific requirements here. As I mentioned before, the SDVOSB must own at least 51% of any incorporated entity, usually an LLC. Profits, on the other hand, are to be distributed commensurate with the work performed, not the ownership. Work performed, not the ownership. However, they have sort of tweaked the regulations within the last couple of years to say, well, if out of the goodness of their hearts or because of the leverage in the negotiation, the non-SDVOSB partner wants to provide the SDVOSB with a larger share, like it has to at least be commensurate with the work share that you do as the SDVOSB, right? But if the JV partner wants to give you a larger share, they can. Now, I haven't seen this a whole lot at all, but they can. So how does this play out? Well, as we'll talk about with the performance of work requirements, the SDVOSB has to perform at least 40%. So what that would mean is that the SDVOSB would have to receive a minimum of 40% of the profit, a minimum. That's the floor. Another way to say that is the non-SDVOSB can't receive more than 60% of the work or 60% of the profit. But in that scenario, the non-SDVOSB could say, you know what? Whatever, if you guys do under 51% of the work, we'll go ahead and give you 51% of the profit anyway. So even though you're doing 40%, we'll give you 51% of the profit. We'll do 60% of the work, but we only want 49% of the profit. So they can do that, again, out of the goodness of their own heart or because of some leverage situation in the negotiation. But otherwise, what normally happens is it just tracks work share. So in other words, if the work share ends up being 50-50, the profit gets split 50-50. But here's the important point. The profit does not get split with the ownership, or it doesn't get split the same as the ownership split. So I know that's a little bit strange and might not be entirely intuitive. This is a very important point here. The joint venture agreement, in addition to complying with all these different regulations, one of the regulations says that you must specify in your joint venture agreement the major equipment, facilities, and other resources to be furnished by each party to the joint venture, right? So you've got to, they want specifics, and they do not want that they do not want you to say, well, we'll figure this out later. This is to be determined. They want you to itemize, and you can see in the bullet point there, if the contract is indefinite in nature, IDIQ, the JV should set forth the anticipated equipment, facilities, and resources. So in other words, if it's IDIQ and you don't know exactly what you're going to be bidding on in terms of task orders down the line, you have to tell them what you anticipate the split will be in terms of work. So it could be a percentage, it could be exact, what equipment, what resources, what personnel. You've got to have that. And the way that I set these up in agreements is I set the joint venture up, remember, because it can go after multiple opportunities. I set it up with an addendum setup. So there's an addenda that you can fill out, and it says, okay, it's for this RFP, this solicitation number. Here is the equipment, facilities, resources. Here's how the work split's going to work. Here's how everything's going to work. And then both parties sign that addendum, and then you have that for the submission with the joint venture. And then you file that, you hold on to it, then hopefully you get the award. Then you know that's sort of your Bible there, right? That's what you go to, and that's what tells you this is how this is what we agreed to. But then if you bid on another opportunity, you create another addenda, right? And that's how it works. So you don't go back and amend the joint venture agreement every time. All right. I've already mentioned this performance of work requirement, so I'm not going to, kill that. But the 40% is the minimum, is the floor for the SDVOSB. That's the least amount of work that you can do. And it's important to note that even though the SBA does have something called a similarly situated rule that can help you on the limitation on subcontracting, that cannot help you on the performance of work. Now, the performance of work, really what it's saying is that if we take a pie and the pie is filled with all the work that's done by the JV members, just the two JV members, I'm not talking about any subcontractors, the two JV members, you've got to make sure that the SDVOSB's piece of that pie is no less than 40%. Or another way to say that is that the non-SDVOSB, whether that's a mentor, large business, or whoever it is, could be another small business, that their piece of the pie is not more than 60%. So those are the endpoints. Anywhere within there, you can certainly give the SDVOSB more than 40%, but that is the minimum. Also, the work performed by the SDVOSB must be more than mere administrative or ministerial functions so that it obtains substantive experience. And the other thing is that affiliates done, or I'm sorry, if you're dealing with a mentor and a mentor protege agreement, you can't sort of sneak around this by having like an affiliate be a subcontractor. The mentor can only get 60% of the work that goes of the total that goes to the two JV partners. Limitation on subcontracting, it's similar and somewhat related, but it's not the same thing as a performance of work requirement. It's just not the same thing. So limitation on subcontracting, what it is saying is it's saying, okay, here's how much the JV partners as a whole have performed. Now, how much are they subcontracting to third parties that are not part of the joint venture? And as we know, generally for services contract, that amount, limitation on subcontracting is 50%. So another way to say this, let's take an example where it's this $10 million contract again. The limitation on subcontracting of a $10 million contract for an SDVOSB joint venture would be for services, contract for services, is that they can't, the two JV partners or the JV cannot subcontract more than $5 million to combine to every other subcontractor. So you could have, that could be one subcontractor, you can give them $5 million, or it could be five subcontractors, you each give $1 million contract. But then the $5 million has to be retained. The other half has to be retained. And that's how you determine compliance with the limitation on subcontracting. Generally speaking, it's based on revenue retained, based on total contract value. Now, with this, there is the ability when I say this, I'm talking about limitation on subcontracting. There is the ability to subcontract to a similarly situated entity. So here's how that would work. You could have a joint venture, and let's say it's an SDVOSB joint venture, but the two partners together can only really perform about 30% of the work. Well, the limitation on subcontracting says they've got to self-perform 50, but they could go find another SDVOSB and have them do 20% of the work. Now together they've done 50%, and the rest of that 50% could go to other subcontractors who are not similarly situated. So hopefully that concept makes sense. All right. And by the way, similar situated entity, it just means an entity that is in the same small business program or set-aside program as the prime contractor. So that has to do with whether that SDVOSB is small or not has to do with what next code you assign to their subcontract. All right. We're getting towards the end here. Hopefully everybody's still sticking with us. I mentioned the certification requirement. So this is how certification works. There's an initial certification that you've got to submit after award, but prior to performance. After award, prior to performance, you say the agreement fully complies with the SDVOSB regulations, and the parties are going to perform the contract. The joint venture will perform the contract with the correct performance of work requirements and limitation on subcontracting. So the two items we just talked about, you're certifying that you understand that and you're doing that correctly. So don't just blindly certify that is the point. It's not uncommon. In fact, I was just mentioning this $80 some odd million contract that, my client just won. We had a whiteboard session where we were going through to make sure everybody understood exactly how this limitation of subcontracting and performance of work was going to work for this contract going forward, to make sure they could make these certifications and then sleep at night to know that they've made them correctly. Then, so there's, like I said, the first certification comes after the award, but prior to you starting performance. Then you do annual certifications, an annual report that, again, says that the performance of work requirements are being met, and got to be signed by both members of the JV. And then again at completion. So there's sort of like 3 sets of certifications: initial, prior to performance, annual, and then at contract closeout. So very important that these certifications are accurate. Now, one thing that's we've seen pop up a few times is if one of the partners to the joint venture goes through an M&A transaction, so they're bought or sold or merged or something like that, there is a requirement that the JV partner that went through that M&A activity must submit a recertification after closing, right? Now, it is possible that the recertification could cause, let's say the SDVOSB gets bought by a private equity company and it no longer qualifies because they're huge, no longer qualifies as a SDVOSB. So that could require you to recertify and notify that you're no longer qualified. Then that gets into a, very interesting question of, well, what happens to future task orders? What happens to options? And the answer is it kind of depends on what contract you're on. You may be able to continue to perform and continue to be awarded options and task orders, but if there's an off-ramp provision, depending on what you're on, especially some of these GWACs have a lot of off-ramp provisions, you may not be able to move forward. Again, coming down the home stretch here, just a couple recent cases and regulations. Remember, for SDVOSBs, the service disabled veteran needs to be in control of the company, and there are very few limitations on that. But the SBA's Office of Hearing and Appeals has found that in a joint venture situation, that it's very similar to just a regular SDVOSB and a minority owner. The non-SDVOSB JV member can have certain veto rights, but it's only over a very few number of topics, like adding a new member to the joint venture, dissolving the joint venture, filing for bankruptcy. It's these very, very limited circumstances, but you cannot, as the non-SDVOSB member of the joint venture, you cannot have veto powers over daily operation activities like hiring and firing people, budgeting, or in this case, it was initiating legal action, so deciding to file a suit. So that's something that's, an important to understand. It will be a limitation of your JV partner. So if they start coming aggressively to try to negotiate this agreement, you have to let them know, look, we can't, because if we get protested, that's how this came up. They won an award, they got protested. When the SBA took a look at their agreement, they said, nope, you gave too much power to the non-SDVOSB JV member. You lose the contract. And that's it. You just lost the contract because your agreement didn't have the right stuff in there. It's important to get these agreements correctly. In this situation, they did not add the responsible manager. That's somebody who used to be called the project manager, but the new regulations call it the responsible manager. It didn't name that person specifically. It didn't provide that addendum that I was talking to about source of labor, negotiation, contract performance, equipment, facilities, resources, etc. And guess what happens? They lost the contract. They initially won the contract as an SDVOSB set aside, and then they lost the contract. This case was last year because they had not been specific enough and had not included everything that's required in the regulations. All right, last one here. I mentioned this before, contracts versus task orders. Again, for that 2-year period, that 2-year period will start with your first award or getting a novation to the joint venture. But as long as you get your IDIQ awarded within that 2 years, the fact that you're getting task orders way after that, that's not a problem. That doesn't count against the 2-year rule. And you could just create another joint venture and then go after other opportunities. All right. I know that's a lot of information, just a ton of information. I look forward to hearing some of these questions here from Zach and see if we can, if I can hit on those. But one thing, just to reiterate, this is my email address right here, brad.reaves, R-E-A-V-E-S, at reavesgovcon.com. If you email me, I will email you a full copy of the presentation. And again, appreciate everybody's attention. I'm ready for some questions.
Let's do it. This is one of those days, Brad. You learn something new every day. So getting to hear this and understanding the nuances, like I walk away with something new. So we did have several questions. So thank you all for registering and sending your questions our way. First is from Katie. She asks, do companies in a JV have to also be in a mentor-protege relationship?
No, great question. They do not. And these two concepts get confused and mixed up all the time. You absolutely do not have to be in a mentor-protege relationship. Although, as I led with, if the company, if you're SDVOSB and the company you want to joint venture with is a large business, then yes, you would have to get them approved as your SBA mentor, and you would have to be their SBA protege. That's the only time when you absolutely have to do that. There might be some reasons, strategic reasons why you would want a mentor protege, but the two do not necessarily have anything to do with each other than facilitating a large business to JV with a small business.
Perfect. Okay. Katie also asked, are JVs for government contracting purposes only granted through the SBA?
Yeah, I think if I'm understanding that question correctly, well, remember that the SBA doesn't approve or certify these joint ventures, right? So you don't, other than that narrow circumstance where I said it was like an 8A where they're getting a sole source award, the SBA is not going to approve these. Now, the sort of larger question of what I think she might be getting at is, can you use these joint ventures outside of federal government contracting? The answer is yes, you could. There's no reason why you could not, but you'd want to be careful. If it's like for state or local or municipal procurement, you might want to check and see the particular procurement rules or that RFP. If you want to use it commercially, I think you could do that too. But really, this is a vehicle that's designed for federal government contracting, and that's how they're used, 99% of the time.
Thanks for extrapolating on that. That's absolutely helpful. Sure. Okay, this one is from Charles. Can a company sub to a JV that they're part of? For example, company one is a large business, company two is a small business. They create a JV called company JV. If company JV wins a prime contract, can they sub to company one or company two? And if so, does any work share revenue? How does that work?
Yeah, so I think that's exactly what they do. I think where it might be a little bit confusion here, like I mentioned, this concept of an unpopulated joint venture. So when we create this joint venture, typically it's going to have no employees and it can't perform the work itself. It has to perform through subcontractors. So yes, it's going to be performing through company one and company two if those are the two members of the joint venture, but it can also have other subcontractors. So that's why, to me, I don't know. It's not a legal term when I call them super subcontractors, but it's like that's what the two joint venture members are. The entity gets the award and then it issues two super subcontracts to the two JV members, and then it may issue other subcontracts to other third parties to the joint venture. So I think the answer to his question is yes. And he talked about work split or he asked about work split, and that, I went through the details of that, sort of the 40% minimum with the performance of work requirement, the limitation on subcontracting, all that applies. But I think the general answer to this question is yes.
All right, perfect. Okay, a couple questions from Michael. The first is, and I think you addressed a little bit of this, but what is the generally expected time to get a JV approved by the SBA? And I think you said you were still looking for the answer, right?
Well, so again, with the MPA, with the mentor protege agreement and mentor protege application, right now, last I heard, they've been taking about 100 days. But the joint venture, I think he said joint venture, the joint ventures do not have to be approved. You do not have to get that joint venture approved. And it would only be if you're getting a mentor protege in place to use that to leverage a joint venture. Do you need to really worry about that time frame? With a JV, I'll just answer that question. Not to be approved, but just to be created. I mean, if somebody tells me the name of the joint venture they want, and I'm creating it as a Virginia entity, I can create the entity same day electronically. Now, the parties are going to have to look at the operating agreement, joint venture agreement, operating agreement, and negotiate that or finalize that. But then you're going to have to get the EIN, the tax ID number, register for the UEI, get the SAM, register. So, it's a couple of weeks usually. So you need at least, I'm talking about if there's no mentor protege involved, it's usually a couple of weeks, not to get it certified by anybody, but just to go through the logistics that you need to do to create the JV entity to be able to bid on a contract. I would like to see that there's about 2 weeks at least. Sometimes it can be done faster, but again, but that's just creation. That's not certification.
I think you answered some of that. So 2 and 3 are, does the JV have to be in place by the RFQ, RFP submission or the award date? Said I think he's seen it in both ways. And then is it better to have an existing JV ahead of time that shows that the JV's been in existence, like a more proven, more stable?
Yeah, so two things. One, yes, it needs to be in place. It needs to exist as of the date that you submit the joint venture. There's some things that if for some reason, you were just like, Brad, I have to create one of these. It has to be bid tomorrow. There's an alternative structure where you can do an unincorporated joint venture and use the managing member's SAM profile. I don't like to do that, or very rarely do that, but you could do that in a absolute fire drill. But generally speaking, you'd be better off to not just better off, but you would need to bid it. Let's put it this way. If you're bidding it as ABJV LLC, you can't bid as that if that entity did not exist on the day that you submit it. So you got to make sure that entity exists before you submit. And then the second question is, would you be better off having it in place? Yes, but not for the reasons that he mentioned. You don't really need the stability or anything like that. Although, it could be helpful if it actually has done work and has past performance, because the contracting officer will have to consider that as well. But remember from the earlier slides, the contracting officers have to consider the past performance of each JV entity and the experience and the business systems and the certifications, et cetera. So since they have to do that, it doesn't matter whether the JV was just created yesterday. They still have to accept all of that. So I think, it's more of a convenience and utility of having the thing so that, and remember, the time clock doesn't start until you receive that first award. So you can have it on the shelf, have it ready to go. And then when the opportunity comes, you don't have to go scrambling to get registered and created the entity and get the SAM registration and do all that. So yes, I create joint ventures all the time that kind of give people a hunting license to go out there and use it to bid, but it's not necessarily because they have an opportunity like boom that's coming, down the pike in 30 days. Although that does happen a lot too.
Yeah, I appreciate the clarity here. That always the additional specific context and response is helpful. So a couple more. Stephen asked, can the past performance of the venturing partners be used for inclusion of a GSA schedule, or only the experience of the JV used for the GSA schedule?
Yeah, the GSA schedule is a completely different animal. So I would say this, that sort of a caveat to everything that I talked about. Everything I talk about works across all of federal government contracting. Don't assume that anything I said today will work in terms of a joint venture with a GSA schedule. The GSA typically wants the entity that's bidding to have its own schedule contract. Now, whether they will allow you to do so, they have their own entity they've created. It's called a CTA, right? A contractor team arrangement where two different contractors can come together that both have GSA schedules, and then they can work together with a lead. And it's kind of a hybrid joint venture, but it's not any of the things I just talked about today. It's not a new entity or anything like that. So I would not assume that anything I said applies to GSA schedules. Assume that joint venture is going to have to obtain its own GSA schedule contract, unless there's some other different program that specific program that the GSA has.
Perfect. Okay. 2 more individuals. Gray asked, what are the risks of joining a JV, and kind of like how long and how many can be done? Which I think you addressed some of this, but clarity is key. Thank you.
Sure. So The risks are that profits and losses are shared, but really, like I said, if you're the SDVOSB and the lead, you're going to be exposed to that as the prime anyway. So that's, I guess the risk is that you invest a little bit of time into some time and money and some legal fees into putting something together. And then you don't use it, or you bid and you don't get awards. Just to give you a sense of like what I'm talking about in terms of time and effort to put these things together, it usually takes about 4 to 5 hours of attorney time to put together, a full comprehensive joint venture agreement and operating agreement that usually runs somewhere to 25 to 35 pages. And that's just because it's pretty complex with all of the exhibits and attachments, all these different certifications, the addendum that are needed. But, depending on what your lawyer's hourly rate is, that could be, a couple $1,000s or more. So that's sort of the lift that you're talking about, but it's more sort of internally the logistics involved in having to get your new business license. There'll be a new tax filing for this entity. So those are sort of some of the, not necessarily drawbacks, just the costs of that. So I think hopefully that answered his question on what the risks were. What was the second part there, Zach?
Or only the experience of the JV. Can only the experience of the JV be used for the GSA schedule?
Oh, he also asked about GSA schedule?
Oh, I'm sorry. Never mind. Like how long and how many JVs can be done?
Yeah.
I think you said there's the 3 and 2 to unlimited now, right?
Yeah, the three and 2 changed to unlimited. But I will say this was a great question that I got the other night when giving this presentation at MVSBC, is there is zero limitation on how many joint ventures you can enter into with like multiple partners. So you could just start entering to JVs, hey, with this team A, and enter into another one with this team A, another one. You could have 10. There's no limitation whatsoever. When you start talking about entering into multiple JVs with the same 2 partners, that's when, after I would say the second time, so once you get to third and subsequent, you're increasing slightly a risk that SBA, really that a competitor would come in and say, wait, I think they're generally affiliated because they've had 5 JVs together. And honestly, if you had 5, the SBA they might get some traction there with that affiliation argument.
That's helpful. Thank you. Okay, last set of questions from Matt. He says, does a JV carry all of the supplier diversity category set-asides that a founding partner company would have, like SDVOSB, 8A, Hub Zone?
Oh, yeah, great question. So what, the question is, okay, if we've got an SDVOSB managing member, the lead member of the JV, the 51% owner, what if they have other statuses? What if they're also woman-owned? What if they're also Hub Zone? What if they're also 8A? And the easy answer is yes. As long as you're certified in all those areas, that JV takes on all of those characteristics. So you can use that JV with your JV partner to go bid on any one of those type of set-aside opportunities. The only thing, remember, is that let's say you are SDVOSB and 8A. If you want to try to get a sole source contract, you will have to, the 8A member, which is the SDVOSB, the lead member, would have to go to your local district office and get that joint venture approved. That's the only time you ever have to get a joint venture approved, is for an 8A sole source award.
Fantastic. Okay, last question. Does the JV have to compete as a standalone entity to gain GSA, and I think it's SINS? Or do they carry over from the founding company?
Yeah, I think back to sort of my answer before with GSA, I would not assume that they do. I don't believe that they do. I think you have to get a separate schedule for the joint venture unless the GSA comes up with some other specific program that's not what they permitted in the past. If anybody's aware of that, if they've got a different program where they're going to allow a joint venture to do that and take advantage, I'm just not aware of it. If they're going to allow like the lead member. So that's different, I think, than because a GSA schedule contract is a contract. It's not a certification. It's not experience. It's not past performance, right? It's not any of those things that these regs say that the contracting officer must consider. Instead, it's a contract award. And so I don't know that there's anything in the SBA regs that require the GSA to consider the contract awarded to a JV member to act like it's a contract awarded to the JV so that you would have those cents.
All right. Well, in similar fashion to the last time I've heard you speak, there's always a plethora of questions. Appreciate everyone for asking these questions ahead of time with registering. But on behalf of our board of directors, our staff, the members of our coalition. I just want to say thank you, Brad, for making time, sharing your knowledge, sharing your expertise and like some of the nuances and, what you're exposed to help, support SDVOSBs and VOSBs like move in the right direction. So thank you for making time and sharing all of this.
Very welcome. Really appreciate the opportunity. Thanks, Zach. Thank you, everybody, for your attention.
Yeah, you're welcome. Very lastly, just thanks to our sponsors again, BAE Systems, Philips North America, and Bank of America. And to everyone watching, you have Brad's contact information right here on the screen. And if you need to contact me for whatever reason, my email is zach.armstrong@nvsbc.org. And just want to say thank you for your participation. We have all kinds of trainings and events on our schedule. So nvsbc.org, we would love to have you participate. And until next time, take good care. Thank you.